Good morning. This is Kathy Walsh from the Tennessee Coalition to End Domestic and Sexual Violence. Welcome to our legislative update. So the 110th General Assembly ended at the beginning of May. And just to give you an idea about the number of bills that were filed and passed, I put this slide together for you. You'll see that 1,794 bills were filed. We tracked 230 of those bills that we thought would be of interest to our group, and 540 bills passed. Now, that doesn't include resolutions in that list. Also, we're happy to report that the Coalition's priority bill to eliminate the statute of limitations on child sex offenses did pass, and we're going to talk about that in just a minute. The Tennessee General Assembly, their sessions are 2 years long. So this was the first year of the 111th General Assembly session, and the General Assembly will reconvene in January of next year. Okay, I've had a little problem with my slides this morning, so I'll try to be careful when advancing them. So this is the priority bill for the coalition this year, is now Public Chapter 499. And this bill did a number of things to both civil and criminal offenses for sexual assault of children. So the first part deals with the civil statutes of limitation. So that's the amount of time that somebody can file a civil lawsuit in a child sex abuse case. So this bill extended that statute of limitations to 15 years from the date the person becomes 18. And that is significant because the current statute is 1 year. Also, it includes if the injury was not discovered at the time of the abuse within 3 years of the discovery. It requires corroborating evidence when action is brought against someone other than the perpetrator more than 1 year from the date the injured person turns 18. And again, I think that you would need corroborating evidence anyway in bringing that sort of suit. It also makes a second or subsequent violation of knowingly failing to make a child abuse report or child sex abuse report a Class E felony. Also makes any intentional failure to make a child abuse report or child sex abuse report a Class E felony. So this increases the penalty. On the criminal side, it authorizes the prosecution for any criminal offense after the commission of a crime if the victim was a minor. And again, this is significant because currently to bring a criminal charge, the statute of limitations is 10 or 15 years. Now this does away with that and says any time after the commission of the crime if the victim was a minor. So this is a huge step forward. We have all seen cases where the statute of limitations has run, even though there could be physical evidence like DNA evidence or a confession from the offender. If the statute of limitations had run, then we were not able to move forward with the prosecution. So this is eliminating the statute of limitations on child sex abuse crimes, and that's A, B, C, and 1D felony. I'm not going to read all of them, but we'll kind of look at the slides so you can see all the various offenses that will be included in this elimination of the statute of limitations. It's a long list. Also included in the statute is that a person may be prosecuted, tried, and punished for one of the offenses at any time if the victim was under 13, or the victim was 13 to 17 at the time of the offense and reported the offense to another person prior to the victim turning 23. Again, that's significant because it raises um, uh, sexual offenses against minors for that 13 to 17 age. If the victim did not meet the reporting requirements, and we're talking about victims that are ages 13 through 17, at a date that's more than 25 years from the date the victim becomes 18, the prosecution is required to offer admissible and credible evidence corroborating the allegations. So again, with that much time having passed, we felt like DAs would not prosecute a case unless they had the corroborating evidence. This is a major step forward in Tennessee in the area of prosecuting child sex abuse cases. Another new statute, Public Chapter 211, increases the punishment for a conviction of aggravated rape of a child from 15 to 60 years to life in prison without the possibility of parole. And when we're talking about rape of a child, that would be a child, again, under the age of 13. And for aggravated rape of a child, that is a child under the age of 3. So if it's aggravated rape of a child under the age of 3, a conviction would be life in prison without the possibility of parole. Public Chapter 374 prohibits sex offenders from overnight visits. Prohibits the sex offender from conducting overnight visits at a residence in which a minor resides or is present if the offender's victim was a minor. There is an exception in there. The prohibition doesn't apply if the offender is the parent of a minor, and one of the following applies. The offender's parental rights have been or are in the process of being terminated. Or any minor or adult child of the offender was a victim of a sexual offense committed by the offender has been convicted of a sexual offense or violent sexual offense of a child under 12 years of age. Public Chapter 360 creates offenses related to childlike sex dolls. And these are sex dolls that look like a minor child. So it creates an offense to possess one of these dolls, to distribute or to transport a childlike sex doll. It's a Class A misdemeanor to possess the doll. It's an E felony to distribute or transport the doll with intent to sell or distribute. Public Chapter 437 relates to unlawful photographing of a minor. It creates a Class C felony of aggravated unlawful photographing. I'll get that word out. When the defendant knowingly photographs a minor, when the minor has a reasonable expectation of privacy. The photograph depicts the minor in a state of nudity, and the photograph was taken for the purpose of sexual gratification of the defendant. Requires a person convicted of aggravated unlawful photographing to register as a sex offender. Public Chapter 104 creates a Class A misdemeanor to influence a witness. Now, this is a bill that was brought by the district attorneys, and it specifically is looking for behavior that doesn't quite constitute coercion, but it's behavior that would intentionally influence or attempt to influence a witness or prospective witness to testify falsely, withhold any truthful information, or elude process, summoning the witness to testify or supply evidence or be absent from an official proceeding to which the witness has been legally summoned. This will apply only to domestic assault cases, and it will apply to the defendant or a person acting in the defendant's um, direction. We had some concerns about this bill being a little too broad because we could imagine a situation where maybe it's the minister of this couple who goes to the jail and ministers to the perpetrator in jail, and then later goes back to the victim and says, I have met with your husband, we've prayed about it, um, he's agreed to go to counseling. He's concerned that if he is found guilty in this case, that he could lose his job um, and might not be able to support the children. So it could be somebody with really good intentions who could end up being charged with this new misdemeanor. So some concerns about that, and also I think we need to do more to educate our district attorneys and people within the court system that there are a lot of reasons why victims may choose not to prosecute, may be terrified of going to court for a lot of different reasons. So I think we need to do more education and keep an eye on how this is being used in our communities. Public Chapter 393 creates a Class A misdemeanor for violating a no-contact order. This bill was named the Leanne Act in honor of a young woman, Leanne Hensley, who was murdered by her boyfriend. And a no-contact order would be, for example, part of a bond condition. So our statute requires when someone is arrested for a crime involving domestic violence that conditions of bail are issued at the time they're released. One of those conditions most often is a no-contact order that tells the defendant that they're not allowed to go about the victim until they go to court. So this creates a new penalty that if they violate that no-contact order, it would be a Class A misdemeanor, which would be the same as violating an order of protection. Public Chapter 422 increases the fine for violating an order of protection. Currently, that fine is $50, no more than $2,500. Now it's going to increase the bottom end from $50 to $100. Top end is still the same, $2,500. Oh, I see I left out the PC number here. This is the Elderly and Vulnerable Adult Protection Act. So it creates some new offenses for abuse of elderly, and there's a list of them there from Class A to Class E felonies. I'm not going to read all of them. Also this year there was a task force that was set up to study financial abuse of the elderly. Public Chapter 410 extends the statute of limitations on second-degree murder from 15 years from the time the offense is committed to any time after the offense is committed. This recommendation, along with the statute of limitations being eliminated on child sex abuse, came from a study the legislature did and recommendations. And so I'm happy to report that the legislature took both of those recommendations on second-degree murder and eliminating the statute of limitations on child sex offenses this year and passed legislation. Public Chapter 421 prohibits using a mobile phone while driving. I thought this was important to include because you're going to want to share this with the staff in your agencies. You may as well want to have a policy related to your staff as well. It prohibits a person from physically holding or supporting with any part of a person's body a wireless telecommunications device or standalone electronic device while operating a motor vehicle, and imposes other similar restrictions on activities such as texting. Already, domestic violence shelters and sexual assault programs that receive federal funding have to have a policy prohibiting texting for their employees. So you may want to take that policy, as I mentioned, and include the use of mobile phones while driving. There are some exceptions in there for police, EMTs, emergency management officers, persons communicating with police, fire, and medical and utility services are included in those exceptions. It, it's a Class C misdemeanor, but it's a fine only. Public Chapter 262 is a result of the Waffle House shooting that occurred in Nashville, where the um, perpetrator had been uh, committed to a mental institution for a while, and his father had been given his weapons, but later those weapons were given back to him before he committed the shooting. So what this bill does is it requires court clerks to report the race, sex, and if known, social security number of a person judicially committed or adjudicated a mental defective to the Federal Bureau of Investigations and the Department of Safety for use in determining a person's eligibility to purchase firearms. And it requires that they keep that information confidential. But this is a way to try to flag people who may be mentally ill, who might take those weapons and commit similar crimes. Public Chapter 421 requires schools to adopt a trauma-informed discipline policy. As enacted, it requires LEAs and public charter schools to adopt a trauma-informed discipline policy. It requires the Department of Education to develop guidance on trauma-informed discipline practices that LEEs must use to develop a trauma-informed discipline policy. We see this as a very positive step forward in providing discipline in schools, but trauma-informed discipline is so very important for children who may be abused, who may be residing in homes where abuse occurs. Public Chapter 356 establishes the Human Trafficking Fund in the State Treasury to provide comprehensive treatment and support services to victims of human trafficking. The grants will be administered by the Office of Criminal Justice Programs to single point of contact agencies. Public Chapter 351 is known as the Human Life Protection Act. And unfortunately, this is one of those abortion trigger bills that have been passing in states around the country. This bill will ban abortion in Tennessee effective on the 30th day after the U.S. Supreme Court overturns Roe v. Wade, or an amendment to the U.S. Constitution to allow states to prohibit abortion. It does create exceptions for situations where the abortion is necessary to prevent the death of a pregnant woman or prevent serious risk of substantial and irreversible impairment of a major bodily function. And it prohibits prosecution of a woman upon whom an abortion is performed or attempted. This bill is particularly concerning because if Roe v. Wade is overturned in the future, it would make abortion illegal in Tennessee. Also, there are no exceptions in here for rape or incest, which we also believe should be exceptions. Public Chapter 251 expands indecent exposure in bathrooms. It redefines public place for the purposes of the offense of indecent exposure to include restroom, locker room, dressing room, shower, designated for multi-person, single-sex use. This bill was seen as a way, um, again, as one of the bathroom bills, which basically, as I understand how this bill would be implemented, would be if you went into the bathroom that is not associated with um, your gender, that um, it could be seen as being indecent exposure. And specifically, there were concerns that this bill would um, target transgendered individuals. So public chapter versions of these bills are available on the Tennessee Government Division Publications website, which is the Secretary of State. For more information and resources on domestic and sexual violence, you can contact the Coalition. There's our website and our phone number. So if you have questions regarding the bills that we've talked about today or any other bills, or accessing public chapter versions of those bills, please feel free to give us a call. Also, we hope that if you are not already a member of the Coalition, that you will consider becoming a member of the Coalition or making a donation to the Coalition today. Your investment helps to ensure that survivors have access to life-saving services, and your contribution supports our public policy advocacy to end domestic and sexual violence in Tennessee. Thank you so much for joining us today. And again, please reach out if you have any questions or need assistance in the future. Thank you.